In the present case, the said notice does indicate that a copy of the notice was also marked to the petitioner, but on a closer scrutiny, we do not find any such evidence of the said notice having been served on the manufacturer, namely the petitioner, in terms of clause 241. In the absence of any such material which could be shown by the learned additional chief standing counsel, we cannot presume that such a notice which has to be mandatorily served by the petitioner in terms of clause 241 of 2011 rules read with section 47 had been served. This point also deserves notice and will have to be taken care of by the appellate authority in as much as the purpose which appears to be for the sending of said notice and which is mandatory is that the aggrieved manufacturer also has a right to get the sample analyzed, and it is for this reason that now under the 2006 act and 2011 rules the procedure for sampling and analysis requires collection and preservation of the sample to be tested in four parts. One part for the aforesaid purpose of an opportunity to the aggrieved manufacturer or affected persons under the Act to get the sample analyzed and tested by a laboratory. Para. This is also necessary because whether it is suspension or cancellation of license or future prosecution in both proceedings, the very foundation of the allegations is the chemical report of the food analyst. The proceedings so initiated has both civil and penal consequences, and therefore the notice envisaged at that stage of sample collection and analysis had to be tendered by the food safety officer, which is a condition precedent for either the designated officer or any other authority to take action on such a foundation. If this opportunity is denied, then the protection given under the Act would be rendered nugatory. It is well settled that a procedure prescribed in law has to be followed, and no deviation can save an action in relation to a statute where the consequences are both civil and penal in nature, as in the present case. The petitioner has made clear statements in the writ petition to the effect that no such opportunity at this stage was given by the food safety officer, and therefore the same deserves to be considered. Para. The question of giving improvement notice by the designated officer is the next stage after the aforesaid procedure has been complied with. Even assuming for the sake of submissions that the competent designated officer had sent a notice on 7th of May 2015, then a reply had been sent by the petitioner alleging compliance to the same by withdrawing the entire products of that particular batch member. This issue also therefore requires to be gone into before the appropriate forum as and when raised in accordance with law. The appellate authority will therefore have to take into consideration the aforesaid submissions raised on behalf of the petitioner. Over.